Call this meeting to order. So welcome to meeting number 11 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics, conformément à l'article.
Pursuant to Standing Order 1083H, and the motion adopted by the committee on Monday, December 13th, 2021, the committee is starting its study on the impact of facial recognition technology.
Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. As you're aware, the webcast will always show the person speaking rather than the entirety of the committee. I will remind members in the room that we all know the public health guidelines. I understand you've heard them many times now. I won't repeat them all, but I encourage everyone to follow them. I would also like to remind all participants that no screenshots or photos of your screen are permitted. When speaking, please speak slowly and clearly for the benefit of translation. When you are not speaking, your microphone should be on mute. Finally, I would remind all of you that comments by members and witnesses should be addressed through the chair. So I would now like to welcome our witnesses for the first panel. As an individual, Ms. Cynthia Khoo, Research Fellow, the Citizen Lab, Munk School of Global Affairs and Public Policy, University of Toronto. And from INQ Law, Ms. Carol Piovesan, Managing Partner. So we'll begin with Ms. Khoo. You have up to 5 minutes for your opening statement.
Thank you. Thank you, and good morning. My name is Cynthia Khoo, and I'm an associate at the Center on Privacy and Technology at Georgetown Law in Washington, D.C., as well as a research fellow with the Citizen Lab at the University of Toronto. I'm here today in a professional capacity, though I'm providing my own views as an individual based on my work at the Citizen Lab, and which are further informed by the work of my colleagues at both the Citizen Lab and the Privacy Center. Today, I'll discuss 4 key concerns with police use of facial recognition technology, each with a proposed recommendation. To begin, I'd like to introduce you to 3 people. Robert Williams was singing in his car when a crime he had nothing to do with occurred. Niger Parks was transferring funds at a Western Union, and Michael Oliver was simply at work. All 3 are Black men who were wrongfully arrested by police relying on facial recognition technology. They've endured lost jobs, traumatized children, and broken relationships, not to mention the blow to personal dignity. These are the human costs of false confidence in and unconstitutional uses of facial recognition technology. This is the same technology that researchers have found is up to 100 times more likely to misidentify Black and Asian individuals, and that misidentifies more than 1 in 3 darker-skinned women, but does work 99% of the time for white men. Although I use examples from the United States, the same could easily happen here if it hasn't already. Racial discrimination against Black and Indigenous people imbues every stage of the Canadian criminal justice system, from carding, arrest, and bail to pleas, sentencing, and parole. Embedding facial recognition algorithms into this foundation of systemic bias may digitally alchemize past injustices into an even more and perhaps permanently inequitable future. Therefore, recommendation number 1 is to launch a judicial inquiry into law enforcement use of pre-existing mass police data sets, such as mugshots. This is to assess the appropriateness of repurposing previously collected personal data for use with facial recognition and other algorithmic policing technologies. Turning to my second point, even if all
I'm going to have to interrupt just for a brief moment. Ms. Khoo, could you adjust the boom on your microphone? We'll try just a little bit higher if you don't mind.
Like this?
Yes, I think that's better.
Better?
Go ahead.
Okay.
3 minutes
Great,
left.
Thank you. Okay. Turning to my second point, even if all bias were removed from facial recognition, the technology would still pose an equal or even greater threat to our constitutional and human rights. Facial recognition used to identify people in public violates privacy preserved through anonymity in daily life and relies on collecting particularly sensitive biometric data. This would likely induce chilling effects on freedom of expression, such as public protests about injustice. Such capability also promises to exacerbate gender-based violence and abuse by facilitating the stalking of women who are just going about their lives and must be able to do so free of fear. Facial recognition has not been shown to be sufficiently necessary, proportionate, or reliable to outweigh these far-reaching repercussions. Thus, recommendation number 2 is to place a national moratorium on the use of facial recognition technology by law enforcement until and unless it's shown to be not only reliable, but also necessary and proportionate to legitimate aims. This may well mean a complete ban in some cases, as several US cities have already done. Canada should not shy away from following suit. This software cannot bear the legal and moral responsibility that humans might otherwise abdicate to it over vulnerable people's lives and freedom. The third problem is lack of transparency and accountability. This is evident in how the public only knows about police facial recognition primarily through media, leaked documents, and FOI requests. Policies governing police use of facial recognition can be even more of a black box than the algorithms themselves are said to be. This gives rise to severe due process deficits in criminal cases. Recommendation number 3 is to establish robust transparency and accountability measures in the event such technology is adopted. This includes immediate and advanced public notice and public comment, algorithmic impact assessments, consultation with historically marginalized groups, and independent oversight mechanisms such as judicial authorization. Fourth and lastly, we need strict legal safeguards to ensure that police reliance on private sector companies does not create an end run around our constitutional rights to liberty and to protection from a reasonable search and seizure. Software from companies such as Clearview AI, Amazon Recognition, and NEC Corporation is typically proprietary, concealed by trade secret laws, and procured on the basis of behind-the-scenes lobbying. This results in secretive public-private surveillance partnerships that strip criminal defendants of their due process rights and subject all of us to inscrutable layers of mass surveillance. I thus conclude with recommendation number 4. If a commercial technology vendor is collecting personal data for and sharing it with law enforcement, they must be contractually bound or otherwise held to public interest standards of privacy protection and disclosure. Otherwise, the law would be permitting police agencies to do indirectly what the Constitution bars them from doing directly. Thank you, and I welcome your questions.
All right, thank you. And now for 5 minutes, Ms. Piova-san, and if I've mispronounced your name, please give it to us correctly, and I won't start your time until after that. But for five minutes.
You've done a great job. Thank you, Mr. Chair and members of the committee. Good morning. My name is Carol Piovizan. I'm a managing partner at Inc. Law, where my practice concentrates in part on privacy and AI risk management. I'm an adjunct professor at the University of Toronto Faculty of Law, where I teach on AI regulation. And I also recently co-edited a book on AI law published by Thomson Reuters in 2021. Thank you for the opportunity to make submissions this morning. Facial recognition technologies, or FRTs for simplicity, are becoming much more extensively used by public and private sectors alike, as you heard Ms. Koo testify. According to a 2020 study published by Grandview Research, the global market size of FRTs is expected to reach $12 billion US by 2028, up from a global market size of approximately $3.6 billion in 2020. This demonstrates considerable investments and advancements in the use of FRTs around the world, indicating a rich competitive environment. And while discussions about FRTs tend to focus on security and surveillance, various other sectors are using this technology, including retail and e-commerce, telecom and IT, and healthcare. FRTs present a growing economic opportunity for developers and users of such systems. Put simply, FRTs are becoming more popular. This is why it is essential, as this committee is doing, to understand the profound implications of FRTs in our free and democratic society. For context, FRTs use highly sensitive biometric facial data to identify and verify an individual. This is an automated process that can happen at scale. It triggers a need for thoughtful and informed legal and policy safeguards to maximize the benefits of FRTs while minimizing and managing any potential harms. FRTs raise concerns about accuracy and bias in system outputs, unlawful and indiscriminate surveillance, black box technology that's inaccessible to lawmakers, and ultimately a chilling effect on freedom. And when described in this context, FRTs put at risk Canada's fundamental values as enshrined in our Canadian Charter and as expressed in our national folklore. While the use of highly sensitive identifiable data can deeply harm an individual's reputation or even threaten their liberty, as you heard Ms. Koo testify, It can also facilitate quick and secure payment at checkout or help save a patient's life. FRTs need to be regulated with a scalpel, not an axe. The remainder of my submissions this morning propose specific questions organized in 4 main principles that align with responsible AI principles we see around the world and intended to guide targeted regulation of FRTs. The principles I propose align with the OECD artificial intelligence principles, leading international guidance on responsible AI, and address technical, legal, and policy and ethical issues to shape a relatively comprehensive framework for FRTs. It is not intended to be exhaustive, but to highlight operational issues that will lead to deeper exploration. The first is technical robustness. Questions that should inform regulation include what specific technical criteria ought to be associated with FRT use cases, if any. Should there be independent third parties engaged as oversight to assess FRT from a technical perspective? And if so, who should that oversight be? Next is accountability, and questions that it should inform regulation include what administrative controls should be required to promote appropriate accountability of FRTs? How are those controls determined and by whom? Should there be an impact assessment required? If so, what should it look like? When is stakeholder engagement required, and what should that process look like? Next is lawfulness, and questions that should guide regulation include what oversight is needed to promote alignment of FRT uses with societal values, thinking through criminal, civil, constitutional, and human rights, and are there no-go zones? And certainly last but not least is fairness. And questions associated with fairness regulation include what are the possible adverse effects on FRTs, on individual rights and freedoms? Can those effects be minimized? And what steps can or should be taken to ensure that certain groups are not disproportionately harmed, even in low-risk cases? Taken together, these questions allow Canada to align with emerging regulation on artificial intelligence around the world, with a specific focus on FRTs, given the serious threat to our values, as balanced against some of the real beneficial possibilities. I look forward to your questions. Thank you.
Thank you very much. And now we'll go to the first round of questions. And first up is Mr. Williams for 6 minutes, please.
Thank you very much, Mr. Chair. And thank you very much to our panelists this morning for coming on board. I'll start with Ms. Koo. Just going to clarify a question I had from your recommendations. Can I just clarify that you have recommended a moratorium on facial recognition technology at this point? Is that correct?
A moratorium on use of facial recognition technology by law enforcement. And the reason it's a moratorium and not a ban is essentially the moratorium would give time to look further into the issue, to launch a judicial inquiry, for example, until we can determine if it is appropriate to use facial recognition, under what circumstances, and with what safeguards, and then including time to put those safeguards in place.
Okay, thank you. And in September of 2020, you wrote that the Canadian legal system currently lacks sufficiently clear and robust safeguards to ensure that use of algorithmic surveillance methods, if any, occurs within constitutional boundaries and is subject to necessary regulatory, judicial, and legislative oversight mechanisms. So I think falling within that theme. We know that right now that algorithmic surveillance methods are still here. Could you tell the committee what kind of safeguards do we need to properly protect Canadian rights today?
Absolutely. So the first one off the bat, I would say, is transparency. A lot of the knowledge that we have of what even is in place these days, as I mentioned, comes because of investigative journalists or document leaks, for example, when really it should be ideally law enforcement and the government telling us that upfront, ideally prior to adoption, and giving the public a chance to comment on the potential impacts of these technologies. That's the first thing. The second thing is we need oversight mechanisms that will assess, for example, algorithmic impact assessments to assess what ahead of time and not after the fact of the potential harms of these technologies, particularly with respect to historically marginalized communities. And then these are kind of higher level principle safeguards, but going more into the weeds, our report focused on the criminal law context, for example. So another example of safeguards would be in the case of specific criminal defendants, there should be disclosure requirements so they're known if these types of technologies have been used in their case, for example, so that they have an opportunity to respond.
Okay, thank you. And in this committee's other ongoing study about the collection and use of mobility data, we heard about the absence of prior and informed consent on the use of personal data and information. How important is it for any collection of Canadians' personal information to have clear and informed consent prior to the collection being undertaken?
I would say as a starting principle, it is extremely important that all Canadians or residents in Canada are able to give prior informed consent to their data being collected. I understand that this is complicated again in the criminal justice context, but I think this is where the connection to commercial vendors becomes really salient, because commercial vendors are collecting so much data that should be done under prior and informed consent, but is not, and in some cases is either permitted to not be or is just not in practice. And then that data gets funneled through to law enforcement agencies. And that's something that I think warrants a lot more warrants a lot of attention from this committee in this issue.
Okay, thank you. Ms. Piavasen, are there any current protections in Canadian law for uses of the collected facial recognition data? And so I can clarify on that. By that, I mean protection regarding how, where, and for how long is it stored and how it can be used or sold.
There are some protections under privacy law that we look at, and again, it depends on who is conducting the collection. So if we're talking about a state actor, you have a patchwork of regulation and common law that will govern how certain information can be collected, stored, retained. Under federal private sector privacy law, for instance, PIPEDA, there are certainly requirements that would, as Ms. Koo said, demand that companies that want to collect such sensitive data do so on the basis of consent. If you look at Quebec, for instance, given that facial recognition technology involves biometric data, you'd be looking at a consent requirement as well. So we do have a patchwork depending on who the actor is that's actually leading that collection. The issue is that we don't have comprehensive regulation or frankly a comprehensive approach when it comes to the use of facial recognition technology as a technology soup to nuts, meaning from the collection of that data through to the actual design of the system, through to the use of that system, having a clear understanding of what are the appropriate safeguards in place from beginning to end, including that collection and storage of that data, the assessment of that data, the disclosure requirements around that data, whether it's a public or non-public public actor. There are different disclosure requirements potentially, but disclosure requirements nonetheless. We have a right to know when aspects of our face are anything that's in sort of a mutable, sensitive data point is being collected and stored and potentially used in a way that could be harmful against us. So really, again, we have this patchwork of laws and regulations depending on who the actor is that's collecting that information, but we don't have a comprehensive or really focused law around facial recognition technology.
Okay, and Mr. Chair, do I have any time left? Okay, well, thank you very much.
Well, you had about 5 seconds. I'll give you 5 seconds more some other time. So we'll go next to Mr. Fergus for 6 minutes.
Merci beaucoup, Monsieur le Président. Puis j'aimerais revenir.
Thank you, Mr. Chair. I would like to thank our two guests today for their presentations. Today, I'm going to speak English, which doesn't happen often.
My reading on in English, so I'll continue asking my questions in English. First of all, let me thank Mrs. Piavasen as well as Ms. Koo for their contributions, not only to our study here, but in terms of what they've written and published beforehand. Ms. Koo, I'd like to start with you. I've read a number of articles that you've been involved with, and one of the ones that certainly has caught my attention was when you co-authored the Citizen Lab report. For the purposes of this committee, I think it would be really important if you were to briefly explain what algorithmic technologies are. And then I'm going to have a few questions which are going to just going to move on from there?
Sure. So that is a great question because algorithmic technologies can be very broad depending on what level you're defining them at. The way we define them in our report, well, I should say actually in our report, we define algorithmic policing technology specifically because if you think about it, an Excel spreadsheet could potentially be an algorithmic technology in the sense that it relies on algorithms. So in algorithmic policing technologies, for the purposes of scoping our report, and I suspect would probably be helpful in scoping for your committee, is emerging technologies that rely on automated computational formulas that are often used to assist or supplement police decision making.
So when we take a look at these algorithmic technologies, in the sense it's based on data which is collected by police, which in itself, and I think you make a very good argument here, but for the purposes for the committee, once again, which in itself has shown to have a pretty strong bias in the collection of that data. Is that not correct?
That's correct.
And so any algorithmic approach which we would adopt in terms of collecting, using this for artificial intelligence purposes, frankly, we're just exacerbating these biases.
I think that would be true in a lot of cases, yes.
In that case, then, I very much understand your second recommendation for there to be a national moratorium on the use by law enforcement of these kind of technologies. But the question which I think I'd be fascinated to find out is, why do you limit it to that? Why wouldn't we want to put a moratorium on the scraping of this kind of information by private sector or non-public sector organizations?
I think that is a really excellent question. So the reason that I'm focused my remarks and will focus most of my comments today on the criminal justice context is purely because that was the scope of my research. And I don't want to speak too far afield from issues that I've actually done that immersive study of myself firsthand. But I do think there are a lot of really good reasons to engage in the same level of depth of research in the use of facial recognition in the, not only in the commercial sector, but even by non-law enforcement government agencies. And there may well be really good arguments to invoke a moratorium on facial recognition in those sectors as well. I can only speak more in depth to the policing context, but that's not to say that it wouldn't also be appropriate in these other contexts.
The reason why I say this is because, as you pointed out, there is a possibility for people to do through indirectly what they can't do directly, while we work out the legal frame, which could be used in terms of the establishment for the use of such technologies. As you pointed out, and I'm also when this technology really came to my attention was 3 years ago now. One of the public broadcasters here in Canada, in Quebec, well, in French Canada, had actually done using AI facial recognition technology, decided to try to identify members of Quebec's National Assembly. And as all studies have pointed out, is that if you're a person of color, if you're a non-white, the error rate increases dramatically. It would seem to me that it would behoove all of us to be careful in terms of trying to establish some limits as to how this information is collected and used in any context, not just in the criminal justice system. Would you agree with that?
I think I would agree with that. Particularly, we've seen so many examples of emerging technologies, both facial recognition, other types of algorithmic policing technologies, where we and society and human rights would really have benefited from a precautionary approach and not a move fast, and the infamous move fast and break things approach. And I do agree, though, with Ms. Pio-Vincent, who talked about taking a more granular approach. I think it was a scalpel rather than an axe. But you're right that we do need time to figure out specifically what the contents of that approach is. And so if being cautious and preventing harm means putting a stop to the use of this technology while we figure it out, I think it would be fair to say that's a sound approach.
Very quickly, I only have about 20 seconds left, and hopefully I can borrow the 5 seconds from my colleague. Is there anywhere in the world that has established a framework for the use of AI, facial recognition, that is?
So I know that the European Union has been doing a lot of work in this area. They would be one jurisdiction to start. And also the US cities that I mentioned, particularly in California and Massachusetts, have been engaging in bans, moratoria, and various frameworks of regulations to different degrees of strictness. So that would be a potential model to look to as well.
Thank you
All
very
right.
much.
Thank you. Very well timed. And with that, we will go to Monsieur Villemeux pour 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thanks to the witnesses for great presentations. I'll ask the same question to both witnesses. I would like you to answer this very quickly because then I'll go to a different level. Facial recognition doesn't mean the end of freedom. Ms. Koo, please.
I think it may be somewhat broad to say facial recognition technology inherently means the end of freedom without more context around that statement.
D'accord, merci beaucoup, Madame Poivezan.
Thank you.
Opportunities to use facial recognition technology that can be very beneficial. I gave the example of healthcare, for instance, but doing so and just having sort of regular, complete acceptance or denial of facial recognition, I don't think is the way to go. There are positive benefits, but there are some serious implications of the use of facial recognition technology, both of which have to be considered as we look to regulation.
Merci beaucoup. Je vais retourner à Madame Koo en lui demandant.
I'll go back to Ms. Koo. The number of images that have been captured, we can't evaluate it, but the images that have already been captured, is it already too late to act because of that?
Well, so in terms of filling some details, I imagine you might be talking about the 3 billion images captured by Clearview AI. And in some respects, you could say it's too late in the sense that, well, Clearview AI is already out there. They've already set up shop. They've sold contracts to all these police agencies. Even if they're no longer in Canada, they're still working in other countries. So from that perspective, maybe it's too late, but it's never too late to act. So for example, Clearview AI was operational in Canada at one point, and now they're not, because we found out, and the OPC stepped in, and there was public outcry. And so I think it's really easy to fall into the trap when it comes to technological issues of technological inevitability, or assuming that technology is here to stay. And that is really not always the case. So even when we talk about other types of algorithmic technologies, for example, the Federal Trade Commission in the United States has started issuing, as part of their remedies in certain cases, the disgorgement of algorithms. So not only deleting data that's been illicitly collected, but even deleting the algorithmic models that has been built on top of that illicitly collected data.
Merci.
So even if...
Merci beaucoup.
Thank you. Ms. Poivezan, is it too late?
I agree with Ms. Koo entirely. I mean, we have seen some movements, particularly out of the FTC, to demand there be, as Ms. Koo mentioned, a disgorgement of the algorithms, a deletion of the data. We've seen movement increasingly to better regulate those entities that are using facial recognition technologies or broader artificial intelligence technology to demonstrate conformity with technical, administrative, and other requirements to show that they are appropriate for the market in which they'll be used, both from a vendor perspective, but also an impact assessment from the user perspective, again, underpinning the importance of accountability in the use of artificial intelligence, including the use of facial recognition technologies. I don't think it's too late.
Merci, Madame Poivezan. Je vais revenir.
Thank you. I'll continue with you now. The Superior Court in Quebec has rendered a decision on Clearview AI to ask them to destroy the data, and they said, we're not in Canada, so we're not going to do it. What would we do in those cases?
The extra-jurisdictional enforcement of these types of decisions are, of course, very difficult, and we've seen this raised by courts before. We take and draw inspiration from the General Data Protection Regulation out of the EU that starts to impose very significant fines, not for actual activity in the jurisdiction, in a European jurisdiction, but for the use of European data subjects, so the use of data of European residents and citizens. So where you've got residents. So where you have opportunities like that to extend jurisdiction and extend enforcement, this is being explored very much. I mean, we've seen this in Quebec, absolutely, with the passing of new private sector reform to the privacy law. And certainly it's a consideration that we saw out of the old Bill C-11 to reform aspects of PIPEDA. We'll see what comes out of the new reform when and should that come.
Merci beaucoup. Et puis, vous avez parlé d'une approche.
Thank you. You've talked about a holistic approach in a recent interview. I'd like you to talk more about this.
Absolutely. So when you're looking at the regulation of artificial intelligence, there are aspects of the data that we need to look at to ensure that it is properly regulated, as well as the use of the technology and the design of the technology. So what we see out of different jurisdictions, including the United States and the EU, is an attempt to regulate artificial intelligence, including facial recognition, very specifically, taking a risk-based approach to the regulation. So if we draw inspiration from the EU's draft Artificial Intelligence Act, we see that there's a criticality of risk that's first anticipated, which means there are some use cases that are considered prohibitive or very high risk. There are others that are considered high risk categories for regulation, and then the risk level decreases. The high risk categories are specifically regulated with a more prescriptive pen, telling both vendors and users of those systems what are some of the requirements that need to be done to verify, validate the system, verify, validate the data, and then impose ongoing controls to ensure that the system is operating as intended, which is a really important point, because when you're using a high risk AI system, recognizing that artificial intelligence is quite sophisticated, it's unique in its sort of self-learning, self-actioning embodiment, then having those controls after the fact are really critical to ensure that there's an ongoing use.
Thank you. We're just a little over time there, and I'd like to now go to Mr. Green for 6 minutes. We can't hear you, Mr. Green. There's no indication of mute. You don't look like you're on mute, but we still can't hear you.
It could be on the
Perhaps there's the button on your headset itself.
How is that?
Okay, that's better. I can hear you fine. I presume the translators are okay. All right, go ahead.
Are the translators okay?
Yep. Yes, go ahead, Mr. Green.
Thank you. I want to begin by acknowledging that today is March 21st, which marks the International Day for the Elimination of Racial Discrimination, honoring 60 years, 1960, in fact, when the Sharpeville massacre happened in South Africa, a police massacre against workers. And I want to take a step back away from the specificity around the tools and talk about the systems for a moment, and draw a direct line between what I believe occurred under Bill C-51 and the implementation of anti-terrorism protocols provincially that led to the analog version of facial recognition, which was the practice of street checks and racial profiling, otherwise known as carding, by local police services, and pick up from there, because I believe that that practice of racial profiling, the analog version, has been in a very sophisticated way ruled out and then re-implemented, as has been identified here through private sector contracts that allow companies like Clearview to do indirectly what police services were doing directly. And I want to also situate the conversation in the system, which is this notion of predictive policing as the basis of my questions, because I believe that the topic of facial recognition may be overly broad to get any kind of real coverage on this. So my questions will be to Ms. Koo, who had laid out in an extensive report some of the bases for recommendations moving forward. And I would like for Ms. Koo to comment on the evolution of predictive policing, its inherent racial bias, and this notion of creating de facto panoptic prisons within our communities that are often over-surveilled, over-policed, and under-serviced. So Ms. Koo, would you care to comment on that, and maybe perhaps draw any lines that you may have come across between the practices of street checks and carding to populate data in things like CPEC, which would obviously be replaced by more sophisticated data such as AI and facial recognition.
Thank you very much for that question. I'm just trying to compile all of my thoughts because there are many issues that could fall under the umbrella you set out. The first thing I would say is that you're absolutely right in tracing that line. And that's something that we heard from a lot of the racial justice activists who we talked to in the research for our report, is saying for them, this is just 21st century state violence, that it used to be done with pen and paper and now it's done with computers and algorithms. And I think one thing that really highlights this racial justice aspect of so-called predictive policing, we're trying to move away from that term just because it's, by this point, it's more of a marketing term and suggests a lot more certainty than the technology can really promise. But because it's been popularized and it's what people know, it essentially, so one way that highlights the racial justice history behind it is asking, would this still be a problem if the technology worked perfectly? And our answer was it would be, because look at what it's being used for. It's used for break and enters and so-called street crime and property crime. And so you will only ever catch a particular type of person who is, if you're looking at a particular type of crime. There's this great satirical project that makes a very compelling point in New York, which published something that they called the white collar crime heat map. That is essentially a crime heat map that only focuses on the financial district of downtown Manhattan. And so why are there not venture capitalists rushing to fund a startup to create that type of predictive policing? It's because even if it worked perfectly, it's still only inures to the benefit and detriment of particular social groups that fall along historical lines of systemic oppression. So that's the first point I'd make. The second point is I'm really happy that you brought up the zooming out contextualization of these technologies, because I believe in the next panel, you'll be talking to Professor Kristen Thomason, who's a colleague of mine, and her comments I would highly encourage you to pay attention to, because she primarily focuses on situating these technologies in the broader context of them being a socio-technical system and how you can't look at them divorced from the history that they're in. Even in, there's a rising field within the algorithmic accountability field that looks at, it's the idea of critical algorithmic accountability or critical AI, where they look at what would it look like to decolonize artificial intelligence studies, for example, or to center these historically marginalized groups, even among the data scientists and the people who are working on these issues themselves. I think I had one or two other thoughts, but maybe I'll stop there for now.
No, I just, with my remaining minute, I recall as a city councilor taking on the process of street checks and racial profiling. And through FOIs as a city councilor, came across an internal memo from the Ontario Ministry of the Attorney General, who under the anti-terrorism protocol stated that street checks provide a unique opportunity for the mass collection of data. And then I reference our own local Hamilton Police Service's use of Clearview. I reference many, many times in which wrongful identity scenarios happened, lawsuits that happened as a response to it, and their constant refrain on this topic of predictive policing. The first time I heard that was at a business planning session with the Hamilton Police, and all I can think about was Minority Report and how terrifying that was as a sci-fi social commentary some 20 years ago. And here we are today. Thank you.
Thank you.
We go to the next round, 5 minutes for Mr. Couric, followed by Ms. Hefner. Go ahead.
Thank you very much, and I appreciate the testimony provided and the questions that have been asked. And I think that this whole discussion, be it facial recognition, artificial intelligence, is really touching on what is a Pandora's box of massive implications in our society, in law enforcement, in technology, in reading on this subject. You see everything from how we log into our phones to evidence that's being compiled without consent for criminal prosecutions. So my hope is to get a couple of questions into to both of you surrounding the interplay between the state and private corporations, and sometimes the contracts that state actors, whether it be police forces or otherwise, will engage private corporations. I'm wondering if you have specific recommendations, first, Ms. Koo, to what regulations should look like to ensure that Canadians, in this case, privacy is protected.
Thank you for that. I'll start with 3 recommendations. The first one is, if law enforcement is considering adopting facial recognition technology or algorithmic policing technology, I think it's a very real option for them not to engage with the commercial vendor at all. For example, the Saskatchewan Predictive Police Analytics Lab built all of their technology in-house specifically to avoid these kinds of problems and being beholden to proprietary interests. So it's publicly funded technology. It's all run by the Ministry of the province, University of Saskatchewan, and the municipal police force, which of course doesn't mean that there are no problems, but at least it does cut out the problems that would be associated with being tied to a commercial vendor. The second thing is that if you are going to procure from a commercial vendor, then we would suggest putting in several really strict upfront procurement conditions. For example, not accepting contracts with any company that has said they're not willing to waive their trade secrets for the purposes of independent auditing, for example, and making sure that they are contractually bound to comply with public interest privacy standards. And then the third way to protect privacy and ensure public accountability is just ensuring less secrecy around these contracts. We shouldn't be finding them out after the fact or through leaks or through persistent FOIs or investigative journalists. We should be knowing about them before they happen, when they're still at the tender stage, and have an opportunity to comment on them.
Thank you very much. And Ms. Pavosian, do you have anything to add?
I very much agree with Ms. Koo's comments. I would add there's an element of stakeholder engagement as well. So we need to be able to reach out to the community, particularly those affected, and have a meaningful discussion about how these technologies are used and what are the implications of these technologies before they're rolled out. I think we've often heard the concept of radical transparency, and when we're talking about something as profound as facial recognition technology, something adopting a concept of radical transparency can be extremely helpful. Also underscoring the point of explainability. So are we going to be able to understand how these algorithms operate, or will we be able to understand the output that they provide? And can we have independent verification to ensure that they are accurate and reliable?
Thank you for that. And I think it's interesting, and even, I have an article in front of me where the headline is, Toronto police use Clearview AI facial recognition software in 84 cases, and the byline is at least 2 cases went to court. So this is something that it's not just a theoretical thing. This is actually happening, and especially as we are faced with a war in Europe and some of the discussions around what facial recognition and artificial intelligence in a military context looks like. You think about the Geneva Convention. It has to do with bombs that are dropped from airplanes, but this is a whole new space with massive consequences. So certainly, I've had a whole host of constituents that have reached out with concern around digital ID and the social credit system, and some of the challenges that are associated when the state is tying your information to aspects of your interaction with government. So I'm wondering if both of you, hopefully I'm out of time.
You're going to have to allow witness a few, about maybe 15 seconds for a reply there, and then we'll have to pick it up in another round. I'm not sure which witness, if you either want to weigh in there for a quick moment to address the questions, or we'll.
I think we thought he was done. Maybe we'll try again in the next round.
All right. Okay. Then we'll hold that thought, and I will go now to Ms. Hefner.
Thank you very much, Mr. Chair, and thank you to the witnesses for your testimony this morning. It's been really interesting, and I think really technical, so I might sound a little bit repetitive, but I just want to make sure that I understand your points of view. And I want to start with PIPEDA, because we know that the government is looking at this digital policy framework right now and trying to adapt it. And it was developed before facial recognition software existed. So I'm wondering if both of you can kind of comment on what exactly sorts of improvements you'd like to see in that legislation, and how could we make that legislation more adaptive to these technologies? Because it's not going to be the last new technology that we have to deal with. These things keep coming up, and the legislation doesn't keep pace. So I'm wondering if you have ideas about how to make it more flexible so that when new technologies like this come into our society, we're more able to deal with the concerns, the privacy concerns. Maybe we'll start with Ms. Koo, just to make that easier. Or sorry, either way.
Sure, thank you for that. So I think when it comes to improving PIPEDA, the number one thing, the most important thing that I think a lot of privacy advocates have been calling for since the creation of PIPEDA is to fix the enforcement piece. Because there are a lot of cases where PIPEDA, in terms of its legal contents and what it allows and doesn't allow, would not in fact allow the activity that occurred. So when it came to Facebook and Cambridge Analytica, for example, that was found illegal under PIPEDA. When it came to Clearview AI, they successfully, PIPEDA captured that activity. But it's the fact that the OPC doesn't have the power to then issue orders. They would have to drag the company into court, and they don't have the power to issue fines, let alone fines at the level of the GDPR. And so I think the single most impactful change that could be made is to give the Office of the Privacy Commissioner of Canada some teeth to actually enforce the orders against companies that are already found to be engaging in illegal activity under PIPEDA or what comes after PIPEDA.
I would agree on the enforcement point. I think what was interesting under the Bill C-11 is that it contemplated a tribunal that would oversee specific and potentially have very more serious consequences over specific violations of the Act. So something that I'm hoping we'll continue to see in the next round. Another point that we saw to an extent in the Bill C-11 was a sort of broadening of various elements of consent as a basis for collecting, using, and disclosing personal information, which, again, we have to be mindful of. PIPEDA is a private sector privacy law. We have to be mindful of some of the positive uses of facial recognition technology, which is why I say it's got to be regulated using a scalpel, not an axe, because there are some very beneficial uses, but we need appropriate safeguards to ensure that those uses are properly controlled and contained and that they feed the public interest. They don't subvert our values. So very important that we see that in whatever new reform to PIPEDA we ultimately get.
Thank you very much. That fits perfectly into my next question, which is, what are the societal benefits that we can see from this technology? Because we've heard a lot about the concerns and the privacy concerns and the discrimination concerns. But are there, other than obviously the commercial benefits to the companies that have this software, what are the societal benefits to this sort of software?
I'm happy to start. I referenced the use of facial recognition in healthcare, where we have seen some examples of FRT being used to monitor patients, make sure that their well-being isn't changing, particularly if they're bed rest, they may not be vocal. So we've seen some very positive uses of FRTs in the healthcare sector that we would want to be, of course, very cautious about. Both the collection, the use of that technology, the retention of that data is very important. The limited disclosure of that data is extremely important. But we can see that there are some very notable positive benefits when you look at it in the health context. Also, I personally use facial recognition to unlock and to verify my identity for my bank, for my phone. Again, wanting strict controls in place. We see it as a convenience. Is it a necessary convenience? No, not necessarily, but it can be a very secure way to go through either a payment process. It could be an airport. It could be to conduct a financial transaction. So there can be positive societal benefits. The issue becomes, is there appropriate disclosure and notice as to the collection of that data, how it's going to be used, and then is there an appropriate retention period that is ultimately in the control of the individual, which is exactly what PIPEDA is intended to do, which is wrestle some of that control over informational privacy back into the hands of users with appropriate.
I'm going to have to move on to, we're getting very close on time here. I'm going to thank you for that response, and I'm going to have to go now to Monsieur Villemeux pour 2 minutes et demie.
Merci.
Thank you very much. 2.5 minutes goes very quickly. Ms. Piovesan, you talked about the GDPR. What would be the best practices that could inspire us? And we also talked about consent that is hard to achieve. But would it perhaps be impossible? So the issue of consent and best practices from the GDPR, please.
Consent can be very difficult depending on the use case, particularly the scalability of facial recognition technology, but it should not be thrown out as a requirement just in and of itself. We need to include consent as a key requirement because we are talking about an immutable biometric data point on an individual. So having appropriate notice with some ability for that individual to make decisions about how they share that information or how it's collected is really critical. I don't want to suggest that consent should never be a consideration when you're talking about facial recognition technology. That's absolutely not true. When we look at GDPR, we can certainly draw inspiration from the profiling requirements that I know Quebec has done, looking at a right to recourse and a right to objection on automatic profiling solely by automatic means. And that's something that is one element that we should consider. But again, I very much encourage the committee to look at the EU's Artificial Intelligence Act. It's not final, but there is some real inspiration that we can draw from there, as well as draft Algorithmic Accountability Act out of the US that's worth looking at as well.
Thank you. And can you tell me more about radical transparency?
Radical transparency really speaks to the entire disclosure process. So allowing people, putting it out there, letting people know who are your vendors, what are your uses, where are you collecting that data, why are you doing so? It's very much about engaging the public as opposed to, as you heard Ms. Koo mention a number of times, this concept of secrecy that undermines the trust we already have, but also starts to subvert some of those really important Canadian values. So radical transparency is starting with the principle that we are going to get out there and let our constituents know what we're doing with facial recognition or any type of really advanced technology that can impact on their rights, bringing them into the discussion in a meaningful way, and then reporting on some of those outputs, including reporting on vendor relationships.
Merci beaucoup.
Thank you.
Mr. Green.
Thank you. I just want to pick up on a topic that my colleague from the block has raised on occasion, and one that I share of interest, and that is on surveillance capitalism. My questions will go to Ms. Koo on the relationship between private companies. We've referenced Clearview. There are others. We know Amazon. We even know Ring technology for doorbells provides an opportunity to privatize and capitalize on public space surreptitiously without the knowledge of people. And I wondered if you could comment on that, and then after that, talk about the susceptibilities for abuse, both by the private sector and by government. And I think about the ways in which it's used voyeuristically. You brought up gender-based analysis there. So I'm wondering if you could just touch on those two topics.
Yes, absolutely. Thank you. So in terms of capitalizing on public space, this is something that we are definitely concerned about. Amazon Ring actually being the poster child for that, because to my knowledge, it has not come up here yet. Although again, Professor Thomason can speak more to this, because I think Amazon Ring was looking at Windsor at one point, where we know there are open partnerships, well, now open partnerships between Amazon and police, where they would actually, police were essentially conscripted as the marketing department of Amazon Ring doorbells, which raises numerous concerns from both the private sector and mostly public sector perspective. Surveillance capitalism is an aspect of this public-private surveillance ecosystem, because it's has to do with the incentive structures, where you have the private companies with their own incentives to collect as much data as possible to capitalize on it. And then a lot of their funding actually comes from government through government grants, whether it's through the guise of innovation or whether it's because they have lobbied government behind the scenes to give them these particular grants. And then the government funds them partly because they buy into the innovation story or because they see, hey, if the company collects all of this data, then maybe eventually we'll have access to that data too. So essentially it's the government and private companies working hand in hand to build out this network of surveillance. The second thing that you said about abuse is, I think we have so many examples of that. Again, one of the questions, actually responding to the earlier question about potentially beneficial uses of facial recognition technology, where my mind went to.
I'm really sorry. I'm going to have to cut you off just to get the last two rounds in, and perhaps hold your thoughts. And I have to shorten the last two, so we'll go 3 minutes each with Mr. Bazan and Ms. Khalid.
Thank you, Mr. Chair. That's unfortunate. I had a lot of questions. So I just want to thank both our witnesses for their great testimony. I want to start with Ms. Koo. You and Catherine Robertson sent a letter off to the Privacy Commissioner of Canada back on October 22nd, 2021. Did you get a response to that letter? And if you did, could you share it with committee?
To my knowledge, I don't think we got a response, but I'll double check with my colleague, Kate Robertson, and we can follow up with you.
Okay, please do, because I really believe that the stuff that you have in here, talking about, three parts that you have as to algorithmic policing technologies. You talk about the moratoriums, having a judicial inquiry, asking the federal government to do that. Government must make reliable, necessary, proportional prerequisite conditions, transparency, more directives on algorithmic policing technologies, or predictive policing, which is even scarier, and so on. So you say in the letter that the worst human rights and charter violations that could occur as a result of Canadian government and law enforcement agencies using algorithmic police technologies. So you want to mitigate that from happening. How do we do that as parliamentarians, as we go forward and wanting to write the proper regulations that respect our charter rights and ultimately bring that balance of transparency, of people's ability to opt in, opt out, and maximize on the technology that's coming down the pipe at us?
Well, I think as parliamentarians, the first thing you could do, and our first recommendation is to launch a inquiry, essentially, or a national commission into these technologies. So for the purpose of this committee, my recommendation was a moratorium on facial recognition. But in that report, we actually called for a moratorium on all algorithmic policing technologies, pending the results of that inquiry, whether it's a national commission, whether it's a judicial inquiry, to do a much more in-depth constitutional and human rights analysis than we were able to do within our report, so that you actually are able to lay out the contents of what's appropriate, what's not, and what safeguards are required, and then actually implement them without knowing that this train is moving ahead in the meantime. So we kind of need a national pause to buy ourselves time to figure out what to do with this technology so that we don't realize way after the fact.
And so the Privacy Commissioner would have the ability to bring about that pause if we believe people's privacy rights are going to be violated. So that buys us that time to do the evaluation. How many police agencies in Canada are using facial recognition technology?
That's a great question. So if it comes to, if you're looking at Clearview AI, then it was several dozen, I believe, who were testing Clearview AI. But for the purposes of our report, we found that who were really using it was the Toronto Police Service, Calgary Police Service. I saw recently, just last month, the Edmonton Police Service signed a contract. And in our report, we saw York and Peel had announced that they were planning to engage in contracts too. This was not with Clearview AI. This is with NEC Corporation. So it's separate facial recognition technology.
Thank you. I'm going to have to go on, but that's a great question. And if you have additional specific information on that, that would be something that would be very helpful probably to our analysts in the preparation of the report. With that, we'll take it, finish this with Ms. Khalid for 3 minutes.
Thank you very much, Chair, and thank you to the witnesses for your very compelling testimony today. Because in the interest of time, I'll just ask Ms. Puevizan. So we see on Facebook when you log in, you put up a photo of yourself and your friends, and all of a sudden, when you go to tag it, there's a list of potential people that could be. And 9 times out of 10 that is accurate. When we have these social media platforms and their use of facial recognition and their algorithms, they kind of create these little circles, or I would say bubbles of societies. And we've seen, how that commercial aspect of it has an impact on that discrimination, on kind of creating extreme views, etc. Now, Ms. Poisson, maybe if you can comment on a little bit how do that commercial aspect, how do we narrow that scope to make sure that, yes, businesses are able to efficiently provide services to consumers without consumers then becoming goats, I would say, or just kind of sheep to be led down a certain path, not just in terms of products but also ideologies.
Thank you for your question. And I have 4 quick proposals. The first is we need to have a risk assessment conducted of the systems. And that is to understand where are the risks, where are the potential unintended consequences, foreseeable harms. That also leads to an impact assessment where you have to look specifically at what are the potential impacts of the system on individuals, on property, on rights, and have that a thorough assessment, as we already see in the privacy space, and as you heard Ms. Koo refer to as an algorithmic impact assessment already adopted by the federal government. Next is that there needs to be clear and plain disclosure so people can make decisions in the commercial context in particular, where you're not talking about any type of, it's not a need to have, often it's a nice to have, and so people need to have that opportunity to understand how their information will be used, not through 20-page privacy policies, which I myself write all the time, but through clear and plain, just-in-time information so that they can make and change their decisions, change their consent if they choose not to continue as they had originally, if they had agreed to provide their face originally, they have the right to change that over time.
Thank you. I appreciate that. And I realize I have 20 seconds, but Ms. Koo, if you wanted to comment on that.
I have nothing further to add, but I will use that time to recommend the work of Simone Brown in reference to Mr. Green's earlier comments on racial justice, because she wrote this book called Dark Matters that traces biometric surveillance back to transatlantic slavery and the branding of slaves, and arguing that that was the origins of biometric surveillance.
All right. Thank you very much to our witnesses. And with that, we will briefly suspend. Yes.
Mr. Chair, before the suspension, this is a good habit for us to be in. Could I ask through you to the guests, to the witnesses, that if there's anything that they feel like they didn't get a chance to fully answer, if they could provide it to this committee in writing for the consideration of reports? I am remiss, and I share the
yes, you may do so, and you have done so now. Thank you, Mr. Green, and I will maybe as a general comment to members. When you ask a complicated question and leave 10 seconds left for the response, you put me in the awkward position of having to cut off our witness. So manage your time so that you can get the answers in rather than just your questions. So I will, with that, we'll suspend.
Mr. Chair, complicated topics have complicated questions. If we can have the witnesses provide their expanded answers, that would be great for the consideration.
Agreed, 100% agreed. So with that, we will briefly suspend while we transition the panels. Meeting suspended. Encourage everyone in the room to take their seats and keep the side discussion down so we can get started. Thank you. So we're getting pressed for time already. I'm going to start off with our opening statements. I'm going to ask our witnesses to absolutely maximum 5 minutes, and I'm going to have to cut everyone off right when we get to that point. So we'll begin. Today we have as individuals Ms. Brenda Shescu, Anna Brenda-Shescu, Artificial Intelligence Governance Expert, Kristen Thomason, Professor, University of British Columbia, Peter A. Allard School of Law, and from the Refugee Law Lab, Petra Molnar, Associate Director. So we'll begin with Ms. Brenda-Shescu. You have absolute max 5 minutes.
Good afternoon, Mr. Chair and members of the committee. Thank you for having me here today. My name is Ms. Anna Brenda-Shescu. I research governance and procurement of artificial intelligence technologies, particularly by government. That includes facial recognition technology, FRT. I will present 2 issues and 3 solutions today. The first issue is discrimination. FRT is better at distinguishing white male faces than Black, Brown, Indigenous, and trans faces. We know this from groundbreaking work by scholars like Joy Bolamwini and Timnit Gebru. Their study found that, and I quote, darker-skinned females are the most misclassified group, with error rates of up to 34.7%. In contrast, the maximum error rate for lighter-skinned males is 0.8%, end quote. FRT generates lots of false positives. That means identifying you as someone you're not. This causes agents of the state to arrest the wrong person. Journalist Kari Johnson recently wrote for Wired about how in the US, 3 Black men were wrongfully arrested because they were misidentified by FRT. Also, HR could deny someone a job because of FRT misidentification or could get an insurance company to deny a person coverage. FRT is more than problematic. The House of Commons' report of the Standing Committee on Public Safety and National Security from 2021 states that there's systemic racism in policing in Canada. FRT exacerbates systemic racism. The second issue is a lack of regulatory mechanisms. In a report I co-authored with privacy and cybersecurity expert Yuan Stevens for the Center for Media, Technology and Democracy, we wrote that as taxpayers, we are essentially paying to be surveilled, where companies like Clearview AI can exploit public sector tech procurement processes. Regulation is difficult. Why? Like much of big tech, AI crosses political boundaries. Also, it can evade procurement policies such as Clearview offering free software trials. Because FRT is embedded in opaque, complex systems, it is hard for a government to know sometimes that FRT is a part of a software package. In June 2021, the Office of the Privacy Commissioner, OPC, was clear about needing system checks to ensure RCMP legally complies when using new technologies. However, RCMP's response to the OPC was in favor of industry self-regulation. Self-regulation, for example, in the form of algorithmic impact assessments, can be insufficient. A lot of regulation vis-a-vis AI is essentially a volunteer activity. So what is the way forward? Government entities, large and small, have called for a ban on the use of FRT, and some have already banned it. That should be the end goal. The Montreal Society and AI Collective, which I contribute to, participated in the 2021 public consultation for Toronto Police Service Board's draft AI policy. Here I extend some of these recommendations along with my own. I propose 3 solutions. The first solution is to improve public procurement. Clearview AI got away with what it did across multiple jurisdictions in Canada because there was never a contract or procurement process involved. To prevent this, OPC should create a policy for the proactive disclosure of free software trials used by law enforcement and all of government, as well as create a public registry for them. We need to glass box the black box. We need to know what we are being sold. We also need to increase in-house AI expertise. Otherwise, we cannot be certain agencies even know what they are buying. Also, companies linked to human rights abuses like Palantir should be removed from Canada's pre-qualified AI supplier list. The second solution is to increase transparency. OPC should work with Treasury Board to create a public registry, this time for AI, especially AI used for law enforcement and national security purposes, also for agencies contemplating Face ID for social assistance like insurance employment. An AI registry will be useful for researchers, academics, and investigative journalists to inform the public. We also need to improve our algorithmic impact assessments, also known as AIAs. AIAs should engage more meaningfully with civil society, yet the only external non-governmental actors consulted in Canada's 3 published AIAs were companies. OPC should work with Treasury Board to develop more specific ongoing monitoring and reporting requirements so the public knows if the use or impact of a system has changed since the initial AIA. The third solution is to prioritize accountability. From the inside, OPC should follow up on RCMP privacy commitments and demand a public-facing report that explains in detail the use of FRT in its unit. This can be applied to all departments and agencies in the future. And from the inside, OPC and the Treasury Board should fund and listen to civil society and community groups working on social issues and not only technology-related issues. Thank you.
Okay, thank you very much. And with that, we'll go to Ms. Kristen Thomason. You have 5 minutes.
Thank you, Mr. Chair, and thank you to the committee. I am joining you from the unceded territory of the Squamish, Tsleil-Waututh, and Musqueam Nations. As you heard, I'm a law professor, and my research focuses on the domestic regulation of artificial intelligence and robotics, especially as this relates to public spaces and privacy. I'm representing my own views here today. I'm very grateful to the committee for the invitation to contribute to this important study. I urge this committee to apply a substantive equality lens to your report and all recommendations made to the government. Much research has already shown how inequitable various forms of facial surveillance can be, particularly with respect to the misidentification of individuals on the basis of race, gender, and age, and the quality and source of data used to train such systems. However, even perfectly accurate facial surveillance systems built on data purported to be legally sourced can reflect and deepen social inequality for a range of reasons. I'll focus on some key points and welcome further questions later, including related to apparent narrow beneficial use cases. First, facial surveillance systems are socio-technical systems, meaning these technologies cannot be understood just by looking at how the system is built, but also at how it will interact with the people who use it, the people affected by it, and the social environments where it is deployed. Facial surveillance consolidates and perfects surveillance and is introduced into a society where, for example, the Supreme Court of Canada, among others, have already recognized that communities are over-policed on the basis of protected identity grounds. Equity-seeking groups face greater quantities of interpersonal, state, and commercial surveillance, and can experience qualitatively greater harm from that surveillance. More perfect surveillance means greater privacy harm and inequity. I urge the committee to explicitly consider social context in your report and recommendations. This includes that biometric surveillance is not new. I encourage you to place facial surveillance within its historical trajectory, which emerged from eugenic and white supremacist sciences. Part of the socio-technical context in which facial surveillance is introduced includes gaps in the application and underlying theories of laws of general application. In other words, our laws do not adequately protect against misuses of this technology. In particular, from my own research, I would flag that interpersonal uses of facial surveillance will be underregulated. I'm very encouraged to see that the committee is considering interpersonal use within the scope of this study and urge the committee to examine the interrelations between interpersonal surveillance and commercial and state entities. For example, while not specific to facial surveillance, the emergence of Amazon Ring police partnerships in the United States highlight the potential interweb of personal surveillance, commercial surveillance infrastructure, and state policing that will at least present challenges to current tort and constitutional laws as interrelations like this emerge in Canada. Personal use facial surveillance has already been shown to be highly damaging in various cases, particularly with respect to technology-facilitated harassment, doxing, and other forms of violence. These uses remain underregulated because interpersonal surveillance in public spaces and public information is underregulated. While governance of interpersonal privacy may not fall exhaustively within federal jurisdiction, I do think this is a crucial part of understanding facial surveillance as a socio-technical system and must be considered within the governance of such a technology. I also do not think that the solution is to criminalize the personal use of facial surveillance systems, but rather to bolster normative and legal recognition of interpersonal rights and regulate the design and availability of facial surveillance technologies. Laws and policies governing technology can have at least 3 foci: regulate the uses of the technology, regulate the user, and/or regulate the design and availability of the technology. Regulation of design and availability may fall more directly within federal government jurisdiction, and better focuses on those responsible for the creation of the possibility of such harm, rather than only reactively focusing on punishing wrongdoing and or compensating for harm that has already occurred. Also, in terms of regulating the use of facial surveillance, I urge the committee to look to examples around the world where governments have adopted a moratorium on the use of facial surveillance, as has been mentioned by other witnesses. And I do also recommend the same in Canada. But more is, of course, needed long-term, including expanding the governance focus to include all forms of automated biometric surveillance, not exclusively facial surveillance. The committee may also consider recommending the creation of a national independent expert group to consult on further refinements of laws of general application and design, use, and user restrictions going forward, perhaps for both federal and provincial guidelines. Expertise must include those
thank you.
from the impacted communities.
I'm really sorry that Ms. Thomason, I'm going to have to cut you off there and go to our third panelist, Ms. Molnar, for 5 minutes.
Thank you so much. My name is Petra Molnar, and I'm a lawyer and an anthropologist. Today, I would like to share with you a few reflections from my work on the human rights impacts of technologies such as facial recognition used in immigration and for border management. Facial recognition technology underpins much of the types of technological experiments we are seeing in the migration and border space. Technologies which introduce biometric mass surveillance into refugee camps, immigration detention proceedings, and airports. However, when trying to understand the impacts of various migration management and border technologies such as AI lie detectors, biometric mass surveillance, and various automated decision-making tools, it is important to consider the broader ecosystem in which these technologies develop. An ecosystem which is increasingly replete with the criminalization of migration, anti-migrant sentiments, and border practices leading to thousands of deaths, which we not only see in Europe, but also at the US-Mexico and most recently US-Canada border with a family that froze to death in Manitoba. Since 2018, I have monitored and visited borders all around the world, most recently at the US-Mexico frontier and the Ukrainian border during the ongoing occupation. Borders easily become testing grounds for new technologies, because migration and border enforcement is already an opaque and discretionary decision-making space, one where life-changing decisions are rendered by decision makers with little oversight and accountability in a system of vast power differentials between those affected by technology and those wielding it. Perhaps a real-world example is instructive here to illustrate just how far-reaching the impacts of technologies used for migration management can be. A few weeks ago, I was in the Sonora Desert at the US-Mexico border to firsthand see the impacts of technologies which are being tested out. These technological experiments include various automated and AI-powered surveillance towers sweeping the desert, facial recognition and biometric mass surveillance, and even recently announced robodogs, like my barking dog in the background, which are now joining the global arsenal of border enforcement technologies. The future is not just more technology, however, it is more death. Thousands of people have already perished making dangerous crossings, like Mr. Alvarado, a young husband and father from Central America whose memorial site we visited. Indeed, surveillance and smart border technologies have been proven to not deter people from making dangerous crossings. Instead, people have been forced to change their routes towards less inhabited terrain, leading to loss of life. Again, in the opaque and discretionary world of border enforcement and immigration decision-making, structures which are underpinned by intersecting systemic racism and historical discrimination against people migrating, technology's impacts on people's human rights are very real. As other witnesses have already said, we already know that facial recognition is highly discriminatory against Black and brown faces, and that algorithmic decision-making often relies on biased data sets which render biased results. One of the most visceral examples for me of the far-reaching impacts of facial recognition is the increasing appetite for AI polygraphs, or lie detectors used at the border. The EU has been experimenting with a now derided system called iBorder Control, and Canada has tested a similar system called Avatar. These polygraphs use facial and emotional recognition technologies to reportedly discern whether a person is lying when presented with a series of questions at a border crossing. However, how can an AI lie detector deal with differences in cross-cultural communication when a person, due to religious or ethnic differences, may be reticent to make eye contact, or may just be nervous? Or what about the impact of trauma on memory, and the fact that we know that we do not recollect information in a linear way? Human decision makers already have issues with these complex factors. But at the end of the day, this conversation isn't really just about technology. It's about broader questions, questions around which communities get to participate in conversations around proposed innovation, and which groups of people become testing grounds for border technologies. Why does the private sector get to time and again determine what we innovate on and why, in often problematic public-private partnerships, which states are increasingly keen to make in today's global AI arms race? Whose priorities really matter when we choose to create AI-powered lie detectors at the border instead of using AI to identify racist border guards? In my work, based on years of on-the-ground research and hundreds of conversations with people who are themselves at the sharpest edges of technological experimentation at the border, it is clear that the current lack of global governance around high-risk technologies creates a perfect laboratory for high-risk experiments, making people on the move, migrants and refugees, a testing ground. Currently, very little regulation on FRT exists in Canada and internationally. However, the European Union's recently proposed regulation on AI demonstrates a regional recognition that technologies used for migration management need to be strictly regulated, with ongoing discussions around an outright ban on biometric mass surveillance, high-risk facial recognition, and AI type detectors. Canada should also take a leading role globally and introduce similar governance mechanisms that recognize the far-reaching human rights impacts of high-risk technologies and ban the high-risk use of FRT in migration and at the border. We desperately need more regulation, oversight, and accountability mechanisms of border tech.
Thank you, Ms. Molnar. I'm going to have to begin the questions, and we're at 25 after 12. What we're going to do is I am going to cut the 6 and 5 minute rounds to 4, and with that we should maybe end a few minutes after 1 o'clock. So I'm going to go to Mr. Williams for 4 minutes.
Thank you very much to our panelists. I'll start with Ms. Brandunescu. Sorry if I butchered your name. Last month, you were part of a response to the Toronto Police Service proposed policy on AI technology use, which included facial recognition. And Section 2 talked about explainability, which was called an important step for ensuring AI technologies remain accountable to users and affected populations. I loved your definition, also glass boxing the black box, very important. So my question is, do we need to define explainability in federal legislation to ensure universal application and understanding of the term? And if so, how would you define it?
Thank you so much. What an easy question to start the round. No, I'm kidding. Yes, so explanation, explainable AI, I guess it's the what we will be told that that's the computational solution we're going to have to make sure FRT can go forward. But what I want to argue is that even though explainable AI is a growing field, but it's actually adding more complexity, not less. So this is because explanation is entirely audience dependent. So that audience isn't really comprised, it's usually comprised of computer scientists and not politicians. So who gets to participate in that conversation is really important, and who's also left out. So I would say that it's not enough to have explainable AI, even because of the neural network type of AI that FRT is. It can never be fully ever explained. And that was also part of our recommendation. So it's really trying to get to the core of what the technology is and understanding the black box in short, but having a technical solution to a very, very problematic technology doesn't mean we should use it to kind of go forward with it and not consider the ban.
Okay, thank you. You had a 2021 paper called Weak Privacy, Weak Procurement, the State of Facial Recognition in Canada. You talked about biometric data protection and how Canada's privacy laws are failing compared to the rest of the world. We've heard of the benefits of the General Data Protection Regulation, GDPR, from a witness in a previous meeting. Would adopting a GDPR-style protection be better for Canada's privacy rights?
So that was, I would give that was the lead of my co-author, Yuan Stevens, who focuses on privacy expertise. But I will try to say that GDPR is a good sort of gold standard to have or best practice so far. I would just argue that this is more than data protection or privacy. This is a conversation about the private sector as well and their involvement in public governance. And right now what we have in our regulation is just private regulation. And I could touch upon the algorithmic impact assessment and our own directive automated decision making more deeply in a future question.
Okay, thank you. And Ms. Thomason, in a March 2020 article with the CBC, you were talking about the Windsor Police use of Clearview's AI's facial recognition tool. You had a quote that said, "How do we know that if the victim is even identified that their information is going to be protected?" And I think that is a key message of the matter as facial recognition becomes more and more widespread. My question to you is essentially help answer the question you posed in the CBC story. How do we make sure Canadians know that their information is protected?
Thank you for the question. And to give some context, I think, to that question, that was also engaging a narrative that arises often in respect to police use of facial surveillance, which is that we use it to protect, in this instance, it was children from harm, but we need to worry about the broader impact on privacy as a social good. Okay. And so what I was getting at there,
I'm afraid that you really weren't left enough time to answer that question, so I'm going to have to cut it off and go to Ms. Sachs. But you may please indeed submit a written explanation if you have one available, or if you'd like to provide one. So go ahead, Ms. Sachs, for 4 minutes, please.
Thank you, Mr. Chair, and Mr. Williams might be pleased that I'm going to be stepping off a little bit from what his question was. I think we're all in agreement that more needs to be done in understanding the use of this technology and making sure that there's a robust consultation with all of those impacted in terms of privacy and also how it's used. A previous witness described that we need to go through this with a scalpel and not an axe. And I appreciate the calls for a moratorium for us to allow to utilize that scalpel. I think it's an important metaphor. Ms. Thomason, in talking about the victims, I've heard a lot of the negative impacts, and I don't disagree with them, but as someone who's engaged in fighting human trafficking for many, many years and understanding the impacts and migration and borders and both its impact on women and children, many of them from racialized minorities, is there not some wisdom of using the scalpel in this technology so that we can effectively protect those who are victims of human trafficking or children who are subject to either assault or child pornography or other tools that we need to find ways to protect them? Is that not a consideration in this discussion?
Yes, thank you for the question. So privacy is a social good that benefits everyone, including the women and children who are often engaged in the narrative of saying that one of the beneficial uses of facial recognition is to protect marginalized or victimized groups. I think it's very important to both acknowledge those potential beneficial uses of facial recognition while nuancing that narrative considerably. In particular, to recognize the way in which the potential erosion of privacy as a social good will also harm women and children. One positive or beneficial use case of facial surveillance, as far as I understand it, is an example from Canada, Project Arachnid. It might be helpful to the committee even to speak to somebody involved with that project. It's a very, very narrowly designed use case of facial surveillance or facial recognition technology more specifically. I'd be happy to speak more about definitions in another question. In which the specific goals and purposes for the creation of an in-house made facial recognition system have been set very, very narrowly. I think that is quite distinct from the broader arguments or narrative that facial recognition should not be banned or should not be limited in various ways because there can be, generally speaking, potentially positive use cases. I think it's far more important to balance the social positive good of privacy in those kinds of discussions. I feel like I'm limited on time. I'd be more than happy to talk about
I'd like to
more,
just try and get one more question if I may. Just one. Oh, goodness. So we may need a submission on this. In December 2021, you gave a submission to Toronto Police Services in regards to their consultations on the use of artificial intelligence technology and made quite a number of recommendations in your submission. If you'd like to highlight one key one here, but I would encourage you to then provide us with the submissions in writing so that we may review them.
Happily. That was a co-authored submission. One key recommendation I'd like to highlight right now is that this technology is not inevitable. The fact that it exists does not mean that it should exist or that we should be using it, does not mean that we shouldn't limit it. I think pointing to some beneficial use cases should not be sufficient to limit our thinking around the potential harms that can arise from more widespread use of the technology. And in particular, thinking more about the interrelationships between how police services, corporate agencies, and individuals might be working together to collect information for the purpose of carceral end goals.
Thank you. And with that, Monsieur Vermieux pour 4 minutes.
You have 4 minutes. Thank you, Mr. Chair. I have a quick question for each witness in the order that they testified. Is facial recognition the end of freedom? Ms. Brandicescu.
I would say no, because we can ban facial recognition. So the end of freedom is a very complex, dire question and statement. And I would argue that, again, this isn't just about mass surveillance. It's about how our governments interact with industry, how they procure different software that they have no idea what they're purchasing. They're implementing.
Parce qu'on est très, très bref dans le temps, je vais revenir.
I'll come back later. Same question for Ms. Thomason.
Previous witnesses, this is a complex question to answer quite straightforwardly, but I would also encourage that the committee consider beyond just facial recognition. There's all forms of different biometric recognition that feed into the conversation that we're having today.
Merci beaucoup, Madame Molnar.
Thank you. Ms. Molnar?
Just encourage a contextual specificity with regards to this question, particularly when we're talking about freedoms for who. And in immigration, of course, we're talking about an opaque and discretionary space that's already very high risk. So in this instance, yes, it can definitely be very limiting.
Merci beaucoup, Madame Brandicescu.
Ms. Brandicescu, is facial recognition transforming the public space in a surveillance space?
Yes, I would argue that there is mass surveillance, but specifically also a discriminatory, racist and sexist surveillance, as we know, because this tech is very discriminatory in the way it is on a very computational level. So the more we accept it in the society, the more it will just be something that we get used to, which I don't want to have that convenience. There was a convenience point made earlier, and sometimes I say the convenience will be the end of us when we use it to open up our phones, and the more it becomes part of your daily lives, the more you just think that it's okay to have it, but actually it isn't, because it can really harm certain individuals and groups, and sometimes it's okay to just not have that technology at all. So it's a bigger question to have. It's a question around the digital literacy. We need to have these discussions, and the critical digital literacy we need to ask the right questions.
Merci beaucoup. Si on va toujours...
So, Ms. Brandicescu, if we're talking about things about age and like the biases for age and race and all that, it's still a world of surveillance even if you're not affected by it, right?
I mean, we can go ahead and talk about data analytics firms and Palantir and others, right, that aren't even FRT. So the world of surveillance goes way beyond FRT, and that's a bigger question to have about our country's military-industrial complex and where these technologies even come from. So we need to, again, zoom out and look at the way that technology is kind of taken over. We need to reflect on what tech solutionism means, on why we put so much money and funding in tech innovation specifically, and why we look at innovation as just being tech prone and not actually funding groups who work very hard on social issues to understand this technology, to create public awareness and also education on this. So I have an optimistic view of, the future, even though I am very critical of this technology. And we have to imagine to think about how we can live without some of this technology.
Thank you.
And we'll be fine.
I'm going to have to move now to Mr. Green for 4 minutes, please.
Thank you. I will begin with my question to Ms. Brandicescu. In your report, Artificial Intelligence Policy and Funding in Canada, Public Investments and Private Interests, One of your main findings is that the current government policy allows companies with links to human rights abuses to pre-qualify as government AI suppliers. And in your previous answer, you talked about the military-industrial complex. We've heard stories of companies who actually tout their technologies being battle tested. Are you aware of any companies who have been pre-qualified as suppliers, not just facial recognition, but throughout AI in this whole spectrum, that have previously been implicated in human rights abuses?
Thank you for the excellent question. And yes, I am aware. So one such supplier is Palantir Technologies, Inc., which is a data analytics company who worked with the US government to plan mass arrests for nearly 700 people and the separation of children from their parents, causing irreparable harm. You could see the report of Amnesty USA on that from 2020. And yet, as I mentioned in my opening statement, Palantir has committed to Canada's algorithmic impact assessment, and it's on that supplier, pre-qualified supplier list, and seen as an ethical measure, that supports responsible AI. So to be committed to an AIA that's supposed to be ethical and then commit these, with another government human rights abuses is very paradoxical and contradictory. And I ask, our government, especially the Treasury Board, who manages that list, to reconsider, again, as I mentioned, to get them off the list, but not just them, others that I haven't looked into deeply about potential human rights abuses.
So what changes in our policy do you think are needed to ensure that a human rights lens is a part of our procurement process?
So I think one is once we write researchers, investigative journalists, whoever, because we're at this point where our open government isn't really open, we still have to file access to information requests and find all this information, is to hear us. So the government now knows that Palantir has caused human rights abuses or is linked to it. So then they should go and that list that's growing, it's like 105 companies now, and take them off the list. And that's one simple step, but it's also then to think about who can commit to the AIA and what does AI really mean and who has input to the AIA. If it's just other companies who can who are engaged when an AIA is published, what does that say about the rest of Canada? So not just the Canadian public, but affected groups, digital rights organizations, civil society bodies. Where are we in the conversation?
This is important work, Mr. Chair, through you to Ms. Brâncoveanu. How concerned should we be about the corporate capture in government's policy development for regulating AI and facial recognition in Canada? And with this in mind, can you describe who is setting the Canadian policy framework for AI and what are the consequences for this?
We should be really concerned. So my next 4 years of research as a PhD student will be around the privatization of the state, specifically with these technologies. And so I think this will just get bigger. As Ms. Molnar mentioned, public-private partnerships are a key point about procuring and deploying and developing and using these technologies. And so we need to make sure that we are in line, like with the Treasury Board, who is hosting all the responsible AI suite, but also look at others like Public Services and Procurement Canada, who really hold a lot of cards here, but are rarely in these discussions. It's always either the Treasury Board and the OPC who are in the conversation, but I never see the procurement people, but really they are a key component here to this conversation.
Thank you. And with that, we'll move to Mr. Kirk for 4 minutes.
Thank you very much. And just before I get into my questions, knowing that we are short on time here, I would invite all of the witnesses here to if there's things that you didn't have a chance to address, whether it be in questions and whatnot, please feel free to send information to this committee. These are big questions with technical answers, and 2, 3, or 4 minutes is certainly not enough time to see them appropriately addressed. I certainly see one of the biggest challenges with addressing this is even just the evolution of the space of artificial intelligence and facial recognition. I'd mentioned in the previous round, with the conflict in Europe right now, the implications of this on how military uses some of this technology, and the Geneva Convention, for example, deals with bombs that are dropped from planes. But there's a whole new space that's opened up. So I'd ask. And I'm probably going to pronounce your name wrong, Ms. Brandesescu. But as this technology is being developed, how, in terms of research, government, private corporations, the testing and understanding of the impacts on this technology and its impacts on society, do you have suggestions as to a path forward that you would recommend to this committee to ensure that there is an appropriate understanding of what this actually means for, in our case, Canadian citizens, and the fact that we are facing a world where AI and facial recognition becomes more and more a part of our daily lives?
Thank you for the question. So I think we can, again, we can push back on tech inevitability and say that we can say no to some of this technology, but that also requires funding and resources for education around these technologies. So again, a lot of these contracts are made behind closed doors in industry, government relationships, public-private partnerships sometimes involve universities and labs, but it's always for a private interest focus. So you want to fund this technologies to build them and then to use them. You don't think about the consequences, and very little money and time and resources go into dealing with the mess that these technologies create and the harm that they create. So we need to make sure that there's a balance in that and move away and reconsider and what we think about innovation when we fund that as taxpayers, especially. So we need to really branch out, because right now I would say that the innovation word has been captured by specifically tech innovations that are designed to develop and deploy these technologies first and ask questions later. And we can see how much harm they have caused, and yet here we are still debating this. So I don't want us to have a Clearview AI case. So what do? The free trial software transparency is really important, because that is beyond FRT. That goes to all of AI systems and technologies that the government uses. Nobody sees that information anywhere. And if we can get that information there, especially for law enforcement and national security, that won't use those excuses to say, like, we're covering trade secrets. We need to go beyond that, because again, if we want to build trust with the government, we need to have that level of transparency to know what even that they are procuring and using, so we can ask better questions.
All right, thank you. And with that, we will now go to Mr. Baines for 4 minutes.
Thank you, Mr. Chair, and thank you to our witnesses for joining us today. And all of you and in our previous panel have highlighted a considerable amount of challenges that we're facing here. My first question is to Ms. Thomason. Recently, you participated in drafting some comments on the Toronto Police Services Board's proposed policy on AI technologies. The first recommendation states that any implementation of AI technologies by law enforcement needs to begin from the assumption that it cannot reliably anticipate all the effects of those technologies on policing or policed communities and act accordingly in light of these impacts. So I'm interested in your view, how often should governments be reviewing the effects of AI technology used in policing?
Often. I know in the draft policy that was ultimately adopted as a policy by the TPSB, the reviews will take place annually, which I think is a positive. I actually think because of the way in which technology progresses and the quantity of data that can be collected and utilized even over the course of a year that in practice, in a perfect world, would not be enough. But of course, reviews and audits take resources and time, and I recognize there are some practical limitations there. But that's one police force in Canada. There are other police forces that we already know are using algorithmic policing technologies and are not engaging in these reviews, at least not to the extent that we are aware of publicly. And there isn't necessarily this sort of public oversight or transparency available. So I think that the TPSB policy is a step forward, is a positive step, but I even then think that there is, it's not enough. There's still a lot that could be done. I think to the extent that the federal government could be involved in establishing some form of guidelines, and then of course oversight for federal level police forces would be a positive step.
Okay, and were your recommendations satisfactory, incorporated into the final version of the policy by the TPS?
I think the final policy did incorporate a number of recommendations that were made. There were a number of parties contributing recommendations to that process, but there were still some weaknesses in the policy. In my view, the policy still very much treats algorithmic policing technologies as inevitable, as a net benefit, so long as we can mitigate some of the risks. And I think what you've been hearing from the witnesses today, including myself, is that that's not the right framework to approach this technology from, given the considerable harms that can be enacted through these technologies and the social context into which they're introduced. One aspect of that policy process that was not formalized but that was discussed was the creation of an independent expert panel that includes expertise from a range of different areas, not simply technical expertise. That didn't come into fruition. There's still some conversation around that. And I do think that that's a step that could be also helpful at the federal level to provide some kind of additional guidance and governance around not just facial recognition, but all forms of algorithmic policing technologies.
Okay, and I noticed I'm also in British Columbia, so my questions are coming to you from Richmond, BC, and I want to know if there's anything in British Columbia that you've looked at and studied with the law enforcement agencies in BC.
Well, I would flag that the Vancouver Police Force uses algorithmic policing technologies, and I think would stand to benefit from looking at some of the process that the Toronto Police Services Board has engaged, but also to engage that process on a federal and provincial level would be much more helpful, I think, rather than simply on a city or municipal police force level, because and TPSB actually recognizes
Ms. Thomason, I'm sorry, I'm going to have to move to the next
no problem.
the next round.
I'll happily provide some submissions.
Thank you very much.
Thank you.
We'll go now to Monsieur Villemure. You have 2.5 minutes.
2.5 minutes. Merci beaucoup.
Ms. Brândușescu, I noticed that you talked about certain things in your response, Palantir. They show themselves as being very cool, but we know that projects like Gotham and Apollo are war projects, and Palantir is a company that serves the military sector, and they use military technology to surveil people. So ethics and Palantir are not synonyms. And could you tell us more about Palantir? And could you also give us the list of the 105 companies that you mentioned earlier, and tell us what we should focus on to better understand the issue? Please tell us more on Palantir.
Thank you for the question, and gladly. So I love that you stated ethics and Palantir are not synonyms, because that is correct. So as I already stated, Palantir is a tech data analytics company, and this is hence the problem with the way AI is defined by the federal government, right? It's the definition is really broad, and I think it's just important for me to note what it is in this meeting. So the Treasury Board defines artificial intelligence as information technology, which is IT, that performs tasks that would ordinarily require biological brain power to accomplish, such as making sense of spoken language, learning behaviors, or solving problems. So this is how Palantir managed to be on this list, which I will gladly share with you. The problem with Palantir is that actually really loved by governments all around the world, but it is getting pushed back right now from the EU, although it is involved in Gaia's X's project. So they were largely funded and created by Peter Thiel and others, and it's many conflict of interest cases within even that governance. The problem is that they're still there. Clearview AI is also still there, although Canada has made a direct statement within OPC around having them out of the country, so to speak, although that's questionable. They're still scraping the web. So with Palantir, they really do data governance around the world, and why they are dangerous is that they still are, even though everyone knows they're not ethical and some people think they're cool, they're still hired and by law enforcement and
Okay, thank you, Ms. Brandishescu. I am going to have to go to Mr. Green. We went a little bit over time there, but excellent information. Move on now for Mr. Green for 2.5 minutes.
Thank you. Thank you, Mr. Chair. My last set of questions will be directed through you to Ms. Molnar, who referenced what I suggest are the dystopian prospects of robo-dogs and drones increasingly being utilized alongside AI and facial recognition at border crossings. Ms. Molnar, can you explain how the existing power imbalances between the state and people crossing borders, especially refugees?
Sorry, Mr. Green. It's come to my attention that you are actually, yeah, I can't see you. You're not, is your camera on? Okay, thank you. All right, I'd stopped your time and time in. Go ahead.
Can you explain how the existing power imbalances between the state and people crossing borders, especially refugees, can be further exploited by the use of AI and facial recognition?
Thank you so much. I think ultimately it comes down to, like you say, the power imbalance in this context. And we already are dealing with an opaque and discretionary decision-making system in which when humans are making really complex decisions, oftentimes it's really difficult to know why particular decisions are rendered and what we can do if mistakes are made. So now imagine that we start augmenting or replacing human decision makers with automated decision making and increasing surveillance. It basically just muddies the already very discretionary space of immigration and refugee processing and decision making. And again, it's all along historical lines of power and privilege. And oftentimes, again, we're talking about communities that already have fewer access to justice and an inability, for example, to challenge mistakes that have really far-reaching implications.
I want to get a little bit more specific through you, Mr. Chair, to Ms. Molnar. In her report, Bots at the Gate, you state that for persons in need of protection under Section 97(1) of the Immigration and Refugee Protection Act, error or bias in determining their application may expose them to the threat of torture, cruel and inhumane treatment or punishment, or a risk of even their life. Do we have a legal or moral obligation to ensure that a refugee process prioritizes the safety and security of the individual and remove any technology or practices that increase the risk of error?
Yes, absolutely. When we're talking about refugee determination in particular, we're talking about an extremely high risk application of technology. And like you rightly say, and then like our report did in 2018, if mistakes are made and if someone is, for example, wrongfully deported to a country that they're fleeing from, the ramifications can be quite dire. So it's very concerning that we are testing and experimenting in this opaque and discretionary space without the appropriate oversights and safeguards. And that is something that has to change because it has real impacts on real people's lives.
Much. And with that, we're going to get to the final two rounds. Mr. Bazan for 4 minutes, and then we'll go to Ms. Hefner and Khaled. Okay, so go ahead, Mr. Bazan.
Thank you, Mr. Chair, and thank our witnesses very much. I'm going to direct my questions towards Ms. Brandishescu. You're well written. I perused at least 3 reports that you've already published, everything from AI for the rest of us, weak privacy, weak procurement, artificial intelligence, policy and funding in Canada, public investments, private interests. Essentially, follow the money and you can see where the private interests lie, as I believe is what you're suggesting. Should governments, federal and provincial in Canada, be funding this type of AI technology and facial recognition technology?
Thank you for your question. So I just have question briefly back. When you say this type of technology is funding, should governments fund FRT?
Well, that's what I'm asking you.
Yeah. Okay. No, they shouldn't. So we're at this point where we're funding a lot of R&D, and that some of the R&D can come up as FRT. So again, the end goal should be a ban. We already see the European Parliament even call for a ban on this. The latest ban that was called, it is possible. We can move from a moratorium to a ban, and then we should. We're not even at a moratorium. And we can start with law enforcement, but as others witnesses have mentioned, if FRT is a problem across the government, it's not only a law enforcement problem, although law enforcement is the worst problem that FRT evokes. So they should not fund it. They should fund civil society, digital rights groups, community groups who are doing this work to showcase all the the harm that comes out of FRT, but also who really know the social issues and the communities they work in. They are the experts, and they should also be involved in the conversation of what the government decides to fund.
So how do we look at both from the policy and directives, the funding of artificial intelligence and FRT, and then what do we need to do on the side of privacy legislation, whether it's the Privacy Act itself, whether it's PIPEDA, what safeguards do we have to build in there to ensure that biometric data is protected?
Okay, so those are a lot of questions. I'll just take up one, which is around, we should turn the directive on automated
and send it in as
decision-making
well.
into an act.
You could also reply in writing down the, after the committee winds up. But if you can give us a quick synopsis, that'd be great.
Yeah, just a quick one would be to improve the directive on automated decision making. Make sure the internal reviews that are written every 6 months actually make it public. We're still waiting for the one that was supposed to be released last year. Apparently, it will be released in April. We're still waiting on it. Again, others have mentioned how we shouldn't rely on investigative journalists to keep doing the work. The public should have this information. We should have updates. We should have homepages on OPCA and Treasury Board and other spaces to show the latest, involvement, like procurement, use of these technologies until they are banned, like in the case of FRT, until they would be banned. But really, the directive itself needs improvement, and I will have those improvements recommendations in writing later. But it should also, we should follow the EU and the US with putting together an act, and an act that also covers the transparency of law enforcement, which is currently not covered by other public AI registries around the world. And I will also put that in writing.
So would that require amendments to our criminal code then to bring in that accountability or the power, control powers leveraged by policing agencies across this country? And then how do we tie that in with the private sector?
I'm sorry, Mr. Bazan, you've only left enough time for a yes or no really to that question, and then we'll have to move on.
Just a maybe, that's not my expertise.
Thank you. And with that, we'll finish it out with Ms. Khalid for 4 minutes.
Thank you very much, Mr. Chair, and thank you to the witnesses. I'll start with Ms. Molnar, if that's okay. So the United States put out a commitment that by 2023, 97% of all of the people that travel through their airports.
I'm going to interrupt you, Ms. Khalid. Maybe I'm going to ask you to adjust your mic a little bit, perhaps, because your audio is not great.
Is that better?
Yes, it's better for us. The translators seem okay. Yep. All right. Carry on.
Okay, great. Thank you. So 97% of all international travelers coming into the U.S. Will go through a facial recognition kind of system. We also see in Canada, our IRCC immigration assessment process applications, not just for refugees, but also for all visitors, for all immigrants that are seeking immigration to Canada, are now being transitioned into an AI model of assessing the applications. Can you perhaps talk a little bit about profiling and how, maybe directly, indirectly, this could impact how an institutional, discrimination could occur?
Thank you. Just briefly, what might be instructive is a comparator between what Canada could be doing and what the European Union is looking at under its proposed regulation on artificial intelligence. There, it clearly recognizes that individual risk assessments for the purposes of immigration and refugee processing are high risk, and there's actually conversations around an outright ban of, again, individualized risk assessment that can be used for profiling and for strengthening systemic discrimination, which is already something that our immigration system is replete with. So there is, I think, an opportunity for the Canadian government to really think through how best to regulate the use of facial recognition technology for the purposes of immigration. But you're absolutely right. It is already in use, both within Canada, but also with its regional partners like the United States, with whom it also shares a lot of the data. Data sharing is an element which we didn't really discuss today, but it's something that I think we all need to pay more attention to.
Thank you. And Ms. Brandishescu, if you wanted to comment on that as well.
Yeah, I agree with Ms. Molnar completely. So I just want to +1 her statement.
Okay, great. Thank you. And I guess lastly, I'll just ask, we've heard some of the pros of facial recognition is, in cases of missing children, locating them, in breaking up child pornography rings, for example. We do give up a little bit of our privacy to ensure the security and well-being of our communities. But where does the commercial aspect of it fall in? If any of you wants to comment on that.
Perhaps just to reiterate that, again, when we're talking about commercial interests and the kind of bottom line thinking that the private sector often brings into the mix, again, it's a very different framework for responsibility when it comes to the high-risk use of technology, particularly at the border or as you're referencing with human trafficking. So again, we need to pay careful attention to the particular actors that are involved in the ecosystem in which these technologies develop and are deployed. And again, none of this is neutral. It is all a political exercise.
If I can also jump in, I think thinking about regulation and limits on facial surveillance through the lens of regulating users or the design or availability of the technology, we can start to think about things like restraints or restrictions on the use of commercial facial surveillance systems, and instead funding or developing in-house systems using data that is not just legally sourced, but sourced through, fully informed consent and processes that ensure the dignity of the individuals whose data is being processed, and that's designed and only used for very, very specific use cases, as opposed to commercial systems like Clearview AI, for instance, that's being used in a wide range of different scenarios, none of which are taking into account the specific social context and implications on the people whose data is being processed or who are being affected by the use of that system. So I think there are ways that we can really distinguish very narrow use cases and not build into a narrative that says that we need facial recognition because it can be used to, protect people from potential harm. Thank you.
Thank you so much. That concludes the round. And with that, I thank our witnesses so much. We had some very important and interesting testimony today. So thank you to all of you. And with that, the meeting is adjourned.